We started this forum 4 years ago in response to our students' demands to deal with the Laquan McDonald shooting that took place here in Chicago. It was at that time that we as the administration here at Chicago Kent made a conscious decision that it is, in fact, our responsibility as an institution of higher learning, and in particular, a law school, to identify, understand, and respond to social justice issues that impact our students, faculty, and staff, and surrounding communities. Therefore, we kicked off our first ever MLK Forum with a discussion about civil rights and the Chicago Police Department. Well, ironically, just last week, on the heels of our 4th annual MLK Forum, sentencing in that matter was handed down. And what many communities of color have taken away from the sentencings of the officers that were involved is that inequities still exist, and we must continue our conversation in our efforts toward equality. So here we are. Let's talk about it. Here to lead our conversation and to set the foundation for the discussion today is Erika Wilson. Erika is the Thomas Willis Lambeth Distinguished Professor in Public Policy at the University of North Carolina at Chapel Hill School of Law. Her areas of expertise include civil litigation, civil rights, education and school reform, public policy, and race discrimination. She currently teaches civil lawyering process and the civil clinic. Professor Wilson's research interests focus on issues related to education and policy, specifically obtaining educational equality for disadvantaged students and the intersection between race and the law. Her articles have appeared in the Cornell Law Review, UCLA Law Review, and the Michigan Journal of Law Reform, among various others. In 2016, her work was selected for presentation at the Harvard-Yale-Stanford Junior Faculty Forum. In 2017, she was awarded the James H. Chadbourne Award for Excellence in Scholarship from the UNC School of Law. Prior to joining the UNC faculty in 2012, Professor Wilson was a teaching fellow at the University of Baltimore. She previously worked as an associate at Arnold & Porter, LLP, where she litigated complex commercial cases involving antitrust, copyright infringement, and product liability. Professor Wilson also served as the George N. Lindsay Fellow for the Education Project at the Lawyers Committee for Civil Rights Under Law, where she engaged in a broad range of litigation and law reform projects involving school desegregation, the No Child Left Behind Act, and special education, school discipline, and federal funding to historically Black colleges and universities. Professor Wilson received her BA in Public Policy from the University of Southern California, cum laude, and her JD from the UCLA School of Law. Welcome, Professor Wilson. Joining in the discussion this evening is Sydney Dillard. Sydney is the head of the Corporate Investment Banking Division at Loop Capital. In addition to managing the corporate team at Loop Capital, Ms. Dillard is responsible for relationship management and the team's business development efforts with corporations across all areas of the firm, including bond underwriting, initial public offerings, private institutional capital raising, and mergers and acquisition advisory. Ms. Dillard serves on the firm's management committee and fairness and valuation committee. She has 30 years of experience, encompassing a long tenure at the Northern Trust Company, where she was a senior vice president and division manager, responsible for commercial banking, treasury management, retirement plan, custody and investment services for large corporations. Outside of Loop Capital, Ms. Dillard is heavily involved in a variety of professional organizations. She also sits on various boards, including the Girl Scouts of Greater Chicago and Northwest Indiana, Montu Dance Theater of Chicago, the Academy of Sciences and its Peggy Notebart Nature Museum, the First Tee of Greater Chicago, National Association of Securities Professionals, and Build On Midway Advisory Board. Ms. Dillard received a Master's of Management in Finance, Marketing, and Management from Northwestern University's Kellogg Graduate School of Management and a Bachelor of Arts in Economics from Stanford University. She holds Series 24, 7, 63, and 79 licenses. Welcome, Ms. Dillard. Also joining the conversation is Candace Moore. Candace is a senior staff attorney for the Education Equity Project, where she advocates for the educational rights of young people through a lens of racial and social justice. She was instrumental in Chicago Lawyers Committee for Civil Rights' relaunch of the Education Equity Project. Candace's work has focused on organizing legal advocacy resources to address disparate discipline and barriers to enrollment for students throughout Chicago and its surrounding communities. She also works in partnership with community-based reformers and institutional policymakers to achieve sustainable and meaningful solutions. She is a graduate of both Loyola University Chicago's undergraduate program and the School of Law. In 2014, Candace completed the inaugural class of the Racial Justice Training Institute, hosted by Sargent Shriver National Poverty Law Center. In 2015, she completed the inaugural class of the Surge Fellowship, a leadership development program focused on addressing the issues of race and class in urban education. In 2015, Candace was awarded the distinct honor of being the year's recipient of the Kimball R. Anderson and Karen Gaddis Anderson Public Interest Law Fellowship. Welcome, Candace. And finally joining our conversation today is Michael Sang. Michael is the co-executive director of the John Marshall Law School Fair Housing Legal Support Center and Fair Housing Legal Clinic. He lectures nationally and publishes extensively on fair housing. Professor Sang also is the coordinator of the John Marshall Law School's Czech Law program. He travels annually to the Czech Republic to teach, and he publishes articles in English and Czech in Czech law journals. Prior to joining the John Marshall faculty, Professor Sang served as a judicial law clerk, was in private practice, and directed the Legal Services Office in Cairo, Illinois. Professor Sang served as a Fulbright professor in Nigeria in 1983 to 84, and a visiting professor in the Czech Republic in 1996. He writes on civil rights issues, and he joined the John Marshall faculty in 1976, and he teaches comparative law systems, constitutional law, and federal courts. Welcome, Michael Sang. Let the discussion begin.
Thank you for having me here today. It's a pleasure to be here, particularly in honor of Dr. Martin Luther King. And so I think it's important at this moment in time, particularly in 2019, to really start having the honest and candid conversations about the stark racial disparities and inequalities that still exist despite the very hard and noble work done by people like Dr. Martin Luther King. And so that's where I want to start my presentation here today in terms of laying the groundwork for where we're at today. So one thing that it's important to understand, right, is that we've had decades of anti-discrimination laws that sought to level the playing field, so to speak, to allow people of color, particularly African Americans, to live the American dream, to have a piece of the American dream that for so long they have been denied. The hope was that America would finally fulfill its promise of being a land of opportunity for all. But unfortunately, that has not happened. Racial disparities and inequalities exist in many facets of American life. And so I want to start by showing you a few examples. This racial disparities particularly exist, I like to say, in areas in which we look to in terms of distribution of resources and power. So one of the most prominent examples of a racial disparity that exists with respect to resources and power is with respect to the wealth gap. And so the chart I have here, hopefully you can see my pointer or not. It's important to understand what this chart depicts is that white households in the middle income quartile own nearly 8 times as much wealth as middle income black earners. And so I want to situate this in terms of middle income earners because I think for various reasons, poverty amongst African Americans is particularly stark. But when you think about opportunity and you situate it with respect to middle income earners, it really highlights the ways in which this is an issue about race and not necessarily class. So important things that the chart depicts is that since 1983, Black and Latino families have seen their wealth fall considerably. In 1983, for example, the average Black and Latino family had $6,800 and $4,000 in wealth, respectively, for the two groups. By 2013, that number had fallen substantially to a little over 1,000 for each group. And we know that part of the reason that happened was because of the Great Recession, all of the things that happened with housing, et cetera. But one of the things that you see there is that there's a huge disparity between the wealth owned by Black and Latino families and the wealth owned by white families. So despite the recession, in 2013, white families still boasted a median wealth of $116,800. Sadly, one statistic that I like to remind my audience is that research suggests that it'll take 228 years for the average Black family to reach the same level of wealth that white families have today. And so we all like to be hopeful and think that this will eventually get better, but the numbers suggest otherwise. As projected in the chart in terms of the projections out to 2024, you can see that the projection is that the wealth gaps will continue to exist. The wealth for African American and Latinos will stay relatively low at 1633 and 1233 respectively. So the wealth gap is one really important indicator of the kinds of racial disparities that we see with respect to the distribution of resources and power. Another important indicator is education. And so it's important to understand it, to situate this again with respect to, in particular, middle income or middle class African Americans. And I'm doing that mainly because I think there's a tendency in the discourse to think that this is an issue of poverty and not race. And so what I hope to do today, and I hope that we can have an honest conversation about, is the extent to which these disparities cut across class, and in some ways they are worse for middle class African Americans and other groups of color. So what this chart depicts is that, first, not on the chart, but an important stat to keep in mind is that the median Black parent lives in an area where the average school performance on state math tests falls in the 30th percentile. So that means that students in the average school attended by Black children are scoring in the 30th percentile on math tests. And so this is in part, and hopefully Candace will talk a little bit about this, due to the confluence of neighborhoods and school assignment that African Americans tend to live in poorer neighborhoods and go to weaker schools as a result of that connection. But even for the median parent with that Black parent with a college degree, people like me, people like many of you in the audience, we live in an area where the average school performance on state math tests still hovers only around the 41st percentile. And so you can contrast that to the average white parent in the same quintile who their child attends a school where the performance is in the 69th percentile on state math tests. 69th percentile, still not great, but the disparity exists nonetheless. Similarly, with respect to housing, right? Again, situating this within the context of not just middle income, but affluent African Americans. And so what this chart depicts is that people with an income of $100,000 or in excess of $100,000. And so what the chart shows there is that affluent black families, again, people with an income of $100,000 or more, are 4 times more likely than white families with the same income to live in a neighborhood that's characterized as a poor or low income neighborhood. You can see that for black families, that number still is significantly higher than for white families. And so we'll talk about it a little bit later in the presentation when we talk about how housing disparities came to be and how they came to lead to the wealth disparities. But this is an important statistic to note, that 37% of African American affluent families are living in neighborhoods that are characterized as poor, compared to only 9% for white families. And so finally, the last depressing statistic I'll show you, I promise, is with respect to upward mobility. And so this one really hit me close to my heart, I have to say. I will confess, I always like to tell my audience, I'm a first-generation college graduate, right? I'm the first person in my family to go to college, to graduate from college. My parents grew up in the Deep South. I like to tell my students, I teach at the University of North Carolina, a school that rejected Pauli Murray. Hopefully a lot of you law students know who Pauli Murray was, and a school in which my parents, my mother and father, would not have been admitted to because they are black. And so in many ways, I represent what people would say is the American dream, right? I now teach at a school my parents couldn't go to. And so the hope is that my son, I have a son named Malcolm, will continue to go upwards and onwards. But these stats suggest otherwise. And so what this the chart depicts is that black children born into families in the middle quintile, families like mine, are twice as likely as whites to go down to the bottom 2 quintiles. And so what that suggests is that even when black children are born into the middle class, they have a high probability of slipping beyond the class in which they were born into the lower quintiles. The numbers there show it for us. 37% and 32% of black children born in the middle income range end up in the lower 2 ranges eventually in terms of upward mobility. So what we're seeing is not upward mobility, we're seeing downward mobility. And the opposite is true for white children born into a similar situation, whereas only a much smaller number of them end up in the lower quartiles in terms of where they came from. And so why am I showing you all these depressing statistics? I'm showing them to you because I think, again, I can't emphasize this enough, that a big part of the reason we can't solve racial disparities is because we don't talk honestly about them. We say that this is a story about class. This isn't about race, this is about class. And so hopefully I persuaded at least some of you that these racial disparities, particularly when you situate them in terms of middle class and affluent African Americans and comparing them to middle class and affluent whites, are real, and it's not about class, it is indeed about race. And so in order to solve these problems, I suggest that we need to understand how these racial disparities came to exist in the first place. And so a key aspect of understanding how the racial disparities came to exist in the first place is to understand the extent to which race and racial inequality was baked into the very fabric of American life as a matter of law. And so as such, my remarks today and the little time I have left to hear today will focus on 3 things. First, I'm going to describe as a matter of law how the law operated to codify the term to codify race as we know it in the first place. And I'll also talk about how the law's codification of race as we know it led to a racial hierarchy that correlates with some of these numbers I showed you with African Americans on the bottom of that hierarchy and whites at the top of that hierarchy. Second, I'll discuss how although we've had a series of anti-discrimination laws and efforts to even the playing field, so to speak, for much of this country's history, we had a very race-conscious system of laws that intentionally operated to favor whites and disfavor those who were not raced as white. And so even though our anti-discrimination laws have sought to dismantle that previous race-conscious system of laws, they are failing to do so mainly due to the embrace of both a colorblind and post-racial ideology that undermines efforts to actually undo the previous race-conscious system of laws. And lastly, because I like to feel hopeful too, I'll conclude with some suggestions, things that we might do to try and get better. So the first thing, the codification of race in the first place. The first thing that's really important to understand is that race is a matter of social construction, not biology. And so what I mean by that is there's no such thing as a race gene. There's no set of genes that makes me black or makes someone else white or makes someone else Asian, etc. And so people might say, well, what do you mean by that? We're different colors, etc. Certainly there are different, people have different pigments, etc., but there's literally no gene that makes someone black or white. Instead, the designations are completely a matter of social construction. For our purposes here, particularly, it's important to understand that there's no gene or set of genes that corresponds to a taxonomy of culturally significant racial categories like we label black and white that would lead to African Americans having a larger, less wealth than white Americans, right? There's nothing biologically innate about African Americans that would lead them to have less wealth than whites. And so instead, again, race is entirely socially constructed. And so this distinction that I'm emphasizing between race as biology and race as social construction is a very important one. It's important because to conceptualize race as biological suggests that group differences are innate, that they are embedded in nature and there's nothing that we can do about them. And so for much of our history, right, we've tried to situate race as biology as a justification for implementing race-conscious laws, but now hopefully we know better and we know that race is not biology, race is a matter of social construction. Once we conceptualize race as a matter of social construction, it acknowledges both the reality that race and the racial disparities and inequalities that exist are the product of social practices. And so if they're the product of social practices, that means that we can do some work to ameliorate them or fix them. So if you're still with me here and you agree that race is a social construct, then the question becomes, why in the United States of America did race become constructed the way that it did? Or put another way, why in the US did we end up with the taxonomy of culturally significant racial categories that we have, such that whiteness is associated with greater wealth, greater opportunity to live in more affluent neighborhoods, etc., and being black is associated with the exact opposite, and if you fall somewhere in between black or white, you're somewhere in between that hierarchy. How and why did that happen? So in order to understand how and why that happened, I already said we're going to discuss those three things. The first important thing to know is that slavery, obviously, right? Laws constructing chattel slavery were the very foundation of the social construction of race as we know it in America. And here I like to really emphasize that slavery was a legal status, right? People often gloss over that part, but the law actually codified the way persons would be treated, whether they would be free or enslaved based on the color of their skin. And so the fact that the law here served a very instrumental purpose in terms of categorizing people and assigning certain rights to them based on their racial designation. And so this is important because it suggests then that a racial designation became so much more than just a physical designation of difference. This is important to know now because we like to talk about skin color, skin only being skin deep, but while that's certainly true, given our history, race is much more than physical difference or designation. It carries a whole history, and from the beginning, carried a particular legal status. If you were categorized as a black or Negro, you were confined to slavery. And so even after slavery was over, it's important to understand the law still operated to afford legal status based on racial designation. And so what are called the black codes, right? Prescribed penalties, etc., for those who were African American or former slaves. If you didn't have a job, for example, or couldn't prove that you were gainfully employed, it was cause for you to be arrested. And so there's a whole backstory to that about how that was another way to engaged in a backdoor form of slavery. But the broader point for our purposes is we start with the slave codes, we progress to the black codes, again, with the law serving an instrumental purpose in terms of providing status to racial designations. And so we have the law then operating to make a difference in terms of operationalizing status based on skin color. And so it's important to understand this because we might often hear, you're playing the race card, you're playing the race card. And so what I'm about to show you now, I want you, if you remember nothing else from what I say, if someone ever tells you you're playing the race card, I want you to methodically show them this presentation and show them how the card got in the deck to begin with. And so I'm going to show you why, after the law operated to make race relevant in terms of racial designation, but then the other thing it did was it operated to intentionally favor whites and to disfavor those raised as not white. And so there's a famous quote from a dissent by Justice Harlan on a case called Plessy versus Ferguson. And so in that case, he says, our Constitution is colorblind and neither knows nor tolerates classes among citizens. And so again, there's an entire backstory to that quote as well that I won't get into here today. But we've often hear, particularly in more recent Supreme Court jurisprudence, our justices cribbing this language, our Constitution is colorblind. But if you watch Maury Povich in my Maury Povich voice, I would say that was false. That is false. That is misleading. That we've always had a very race-conscious system of laws. And so in order to understand those inequalities that I showed you at the beginning of the presentation, what I'm going to do now is walk you through examples of some of the race-conscious laws, and then we'll talk about how that system of race-conscious laws laid the very foundation for the racial inequalities that we have here today. So the first category of the race-conscious system of laws that we had was with respect to immigration, right? The Immigration and Naturalization Act of 1790, in the very text of the statute, it says that any alien being a free white person, so from the beginning, making whiteness a prerequisite to becoming a citizen. And so you can see maybe that this, it does arguably have echoes in the debate that we're having today about who's a real American and who is not. The ways in which that debate is very much colored by lines of race. So we start with immigration, making immigration and naturalization, making whiteness a prerequisite to citizenship. And so in a series of cases called the prerequisite cases, the Supreme Court was actually asked to decide and adjudicate whether certain nationalities qualified as white. So essentially what you had is you had people, whether they were Arab or Asian, Chinese, going to court and trying to make the case that they should be categorized as white under the law so that they can become a naturalized citizen of the United States. And so this was the genesis of race in our immigration laws. It only continued from there. In 1882, the Chinese Exclusion Act excluded Chinese from immigrating to the United States. The act was renewed for 10 years in 1892. By 1902, Chinese immigration was made permanently illegal and remained illegal. They remained ineligible for citizenship until 1943. So I'll self-disclose again here. My mom was born in 1943. So this is not that long ago that this happened. Subsequent to that, another important part of our race-conscious system of immigration laws was that the Immigration Act of 1924 limited the number of immigrants allowed entry into the United States based on their national origin. Its specifically purpose was to deny entry to Mexicans and disproportionately to those from Eastern and Southern Europe and to the Japanese. And so this system of racial prerequisites to immigration went on for some time, actually. It was not finally removed until 1965 was when we finally got rid of the quota system of immigration, and 1952 was actually when we got rid of some of the other racial prerequisites for immigration. So 1965, a landmark date in terms of whiteness not being a total prerequisite for citizenship. So first we have immigration. Then we have property rights. And so in terms of property rights, there was a merging of citizenship in order to have property rights. And so, of course, maybe I should have started here. You have to start with the dispossession of the lands from Native Americans. A famous case called Johnson versus McIntosh, which pretty much codified the doctrine of discovery, which gave exclusive right, extinguished the right of title that Native Americans held to land and gave it to so-called Christian European discoverers subject to the right of Native American occupancy. And so that's important because it paved the way in 1830 for the Indian Removal Act, which resulted in the forcible relocation of Indians in order to make way for white settlers. And so in addition to that, then you had the Homesteading Act of 1862, and I've highlighted the language in red there for you. What the Homesteading Act did was gave away millions of acres of land in territory that was west of the Mississippi, land that used to belong to Native Americans. And so the law that did that limited the ability to take part in homesteading to those who were citizens of the United States. But even though it doesn't directly say white in the text of the law, I just told you earlier, citizenship was limited to white people. And so you can draw your own conclusions about that, what that means in terms of who disproportionately benefited from homesteading, being able to get those many acres of land. And then the last example, and maybe more recent, and hopefully Michael will talk a little bit more about this, is the New Deal programs. So prior to the New Deal, owning a house in America was a big deal, something that not everyone could do. And so the federal government sponsored a program that offered insurance to private lenders to encourage them to invest in residential mortgages. And so essentially the FHA would insure private loans such that if the borrower defaulted, the government would come in and pick up the tab. Without the FHA insurance, private lenders were very reluctant to lend to individuals. And so by the end of 1972, the FHA had assisted 11 million families in buying houses and another 22 million in making home improvements. But importantly, the FHA also used race-conscious policies that had the effect of denying black borrowers access to loans. And you can see in the text of language I highlighted here, this was the underwriting manual that underwriters used in order to decide whether or not they were going to lend to someone. And if you look at the first full sentence, it says, if a neighborhood is to retain stability, it is necessary that the property shall continue to be occupied by the same social and racial classes. And so here what you have the FHA program doing is codifying the very racial segregation that we still see here today. In addition, same manual says the underlying language, the more important among the adverse influential factors are the ingress of undesirable racial or nationality groups. And so you might guess who might be pegged an undesirable racial or national origin group. And so the effect of this was to, again, give whites a tremendous advantage in terms of being able to buy homes that many of them later used to take out equity to start businesses, go to college, etc. And so in addition to the housing programs, other important New Deal programs or laws to understand and their racialized effect, the Social Security Act, Social Security as we know it, was originally excluded African Americans, Mexicans, and Asians by excluding occupations predominated by those groups from being eligible for Social Security. Underrated one, the Wagner Act, granted unions the power of collective bargaining. Unions were a big part of our middle class push, but it also allowed unions to exclude non-whites. So what that meant was that whites were able to get access to union jobs with better benefits, et cetera, and non-whites could be excluded. And so importantly, to understand the scope of this race-conscious system of laws, right? This had a huge impact. I went through relatively quickly what I hope is a persuasive case that the law has historically favored whites, and it wasn't so long ago that happened. And so the scope of it, for example, 270 million acres, or 10% of the total land area of the United States, was given to private individuals through homesteading. And so almost all of those people who were able to take advantage of that because of the way the law was written were white. Racial barriers to citizenship weren't removed until 1952 or in 1965, I told you that. And then most startling and most, I guess, important for our purposes here in terms of understanding the racial wealth gap, between 1934 and 1962, the federal government backed $120 billion in home loans. More than 98% of those loans went to whites. And so using California as an example, between 1946 and 1960, 350,000 new homes were built with federal support. In Northern California, fewer than 100 went to African Americans. So that's a huge disparity, and a lot of people get wealth through home ownership, and to that extent, that explains in some part the racial wealth gap. Okay, and so I've explained to you how we got here, right, in terms of the law and the law's role in building racial disparity, but why are we still here? We had the 1964 Civil Rights Act that prohibits discrimination, and we don't have, for the most part, those kind of race-conscious laws on the books anymore. So shouldn't things have changed, right? This is, my students like to tell me sometimes, Professor Wilson, stop bringing up old stuff. It's 2019. What are you talking about? Why are we still here? And so the reason that we're still here, I like to argue, is that beginning with Brown versus Board of Education, right? I showed you the language from the Plessy versus Ferguson decision. Our Constitution is colorblind language. And so a lot of civil rights advocates adopted that same language. I pulled for you here language from the appellant's brief in the Brown versus Board of Education case. And so very prominently, they argued that the Constitution is colorblind, is our dedicated belief. So they push this idea that the Constitution should be colorblind. But there are some problems with conceptualizing the Constitution as colorblind when you've had a long history of race consciousness. And so what the anti-discrimination laws did, starting with the Civil Rights Act, is to prohibit discrimination. They said, stop discriminating on the basis of race in key areas like employment, housing, public accommodations, and education. All of the laws favoring whites, all of that's over. We're going to stop discriminating. We're going to be colorblind and treat everyone the same. But inherent in that are some problems, right? Anti-discrimination laws are undergirded by the normative belief that we shouldn't make differentiations amongst people based on race. And so this commitment to anti-differentiation has led judges, laws, courts to situate affirmative action or things that give benefits to people of color on a remedial basis as being the moral and legal equivalent of Jim Crow segregation and other forms of racial oppression. So a system of colorblindness suggests that you should not make any distinctions based on race, that everyone should be treated the same, and that whether or not you are enacting a race-conscious affirmative action program or having Jim Crow water fountains, those things are morally and legally the same. And so this is problematic in many ways because a legal framework that's undergirded by anti-discrimination or no differentiation neglects the necessary work of anti-subordination, right? You cannot have the many decades, centuries of laws favoring whites and then just say stop and hope that the disparities that I showed you at the beginning of the presentation would go away because they won't. And so I think that Lyndon B. Johnson captured it best. So I'm going to show you a brief clip of Lyndon B. Johnson and a speech he gave at Howard University.
Freedom is the right to share fully and equally in American society, to vote, to hold a job, to enter a public place, to go to school. It is the right to be treated in every part of our national life as a person equal in dignity and promise to all others. But freedom is not enough. You do not wipe away the scars of centuries by saying now, you are free to go where you want, and do as you desire, and choose the leaders you please. You do not take a person who for years has been hobbled by chains and liberate him, bringing up to the starting line of a race, and then say, you are free to compete with all the others, and still justly believe that you have been completely fair. Thus, it is not enough just to open the gates of opportunity. All our citizens must have the ability to walk through those gates. And this is the next and the more profound stage of the battle for civil rights. We seek not just freedom, but opportunity. We seek not just legal equity, but human ability. Not just equality as a right and a theory, but equality as a fact and equality as a result.
Okay, so I wanted to show you that clip because it's an important precursor to what we know as race-conscious affirmative action, particularly with respect to federal government contracting. And so before showing you the clip, I mentioned that one of the problems with adopting a colorblind approach to the way in which we view the Constitution and the way in which we situate our anti-discrimination laws is that it doesn't do much to undo the prior history. And so that's what President Johnson was alluding to in his speech. And so in contrast to anti-discrimination is a principle called anti-subordination. And so anti-subordination suggests that the law should aim not to just prohibit discrimination, but to undo subordination, to make level opportunities for all, and that in order to do that, you might have to take into account race. You might have to be race conscious in order to do that. In order to eliminate the racial disparities I showed you earlier, it's not enough to say stop discriminating. You've got to do something affirmative and take affirmative steps. And so, importantly, affirmative action, right, was one way in which the law sought to do that. And so, I think Sydney will talk more about the Small Business Act in particular, but I wanted to show you the ways in which our law or our legal jurisprudence has shifted away from thinking that anti-subordination is an important goal and shifted further to an ideology of colorblindness. So the famous case Bakke, right, we know that Bakke gave us diversity as a compelling state interest, but at the same time it rejected this idea that remedying general past societal discrimination was a compelling state interest that would justify the use of race-conscious admissions. And so Justice Blackmun had a really key quote in his concurrence where he talks about, given the legacy of unequal treatment, that it's important that we essentially take affirmative steps to open doors. And so that it's important not to just look at the past and see it as the past, but that we must enact remedies that acknowledge and to address the past. And so you can see this was a concurring opinion. It wasn't in the majority. And so I want to walk you through a few more of the affirmative action decisions and look at the way in which the language shifted in those cases. So in Fully Love versus Klutznick, which was a case in which the court was asked to decide whether or not basically a federal government set-aside program for minority businesses was lawful. And so this was in 1980, and Justice Stewart in his dissent said, "Today the court upholds a statute that accords a preference to citizens who are Negroes, Spanish-speaking Orientals, Indians, Eskimos, and Aleuts for much of the same reasons. I think today's decision is wrong for the same reason that Plessy versus Ferguson was wrong, and I respectfully dissent." So in 1980, this view, again, I mentioned the idea that Jim Crow and affirmative action are morally equivalent. This was in a dissent, right? Fast forward a few years, and that line of reasoning is no longer in the dissent. It shifts over to being in concurring and majority opinions. In the city of Richmond versus Croson, another set-aside case involving minority contracting. We've got Scalia concurring, so that should give you some idea of what the majority opinion said. And he says, the difficulty of overcoming the effects of past discrimination is as nothing compared with the difficulty of eradicating from our society the source of those effects, which is a tendency fatal to a nation such as ours to classify and judge men and women on the basis of their country of origin or the color of their skin. So here you see prominently this idea that anti-differentiation is wrong across the board, that we shouldn't make these racial distinctions even when we're trying to do so for remedial benefit, the remedial benefit of traditionally marginalized groups. And so fast forward even more into the 90s, 95, Adirondack, another Thomas in the concurring opinion. And so he says, in my mind, government-sponsored racial discrimination is just as noxious as discrimination inspired by malicious prejudice. In each instance, it's racial discrimination, plain and simple. Again, situating both discrimination against groups of color with benefits to groups of color to remedy discrimination as being the same. And then my favorite, and parents involved, you've got Justice Roberts saying, the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. And so this, for me, is the complete nexus, the shift away from an anti-subordination principle, if there ever was one, to the colorblind ideology winning out. And so it's important to understand that, and understanding why are we still here, why do these disparities exist, because we have not done the work to dismantle the previous system of race-conscious laws. And so lastly, in addition to colorblindness, we're also, or at least we were, it'll be interesting to see what happens given the recent shift in the Supreme Court. We're also now slipping into post-racialism, this idea that colorblindness is aspirational, right? It says that we shouldn't see race, we should treat everyone exactly the same, no distinctions. Colorblindness says that we've cured racism, basically. It's over, there's nothing to see here, and we saw this in Shelby County, the voting rights case that got rid of pre-clearance requirements for the Voting Rights Act. And so I'll just say that to put a bow on this, both the colorblind and post-racial legal regimes perpetuate racial inequalities and maintain the status quo because, again, they don't do the work of dismantling the prior system of race-conscious laws that favor whites. But most, I think, pernicious is that it legitimates the existing system of resources, right? People look at the racial disparities and they might say, there are no longer any laws that discriminate against groups of color. These disparities exist because something's wrong with those groups of colors. This is a natural, fair distribution of resources. And so it results in difficulties in remedying the problem because the problem is not situated with the system but individual groups, and suggests that individual pathologies are responsible for those disparities. And so where do we go from here? So I've told you a lot that's maybe a little bit depressing, but how do we fix this? And so one of the solutions, and I'm happy to talk about it more in the question and answer period, is what I call targeted universal programs. I think for better or worse, we might be able to agree that specific race-conscious programs are not politically palatable. We've seen that with affirmative action, the legal battles against affirmative action. So if we can't have specific race-targeted programs to undo the previous system of laws, how do we proceed as a matter of politics, frankly? How do we do something that's politically palatable? So what I suggest is targeted universalism, and that's the enactment of universal programs in ways that we know will disproportionately impact groups of color. And so a professor named Sandy Darity has this idea about baby bonds in which you provide trust funds of between $500,000 and $50,000 depending on the wealth of the family, because we know the wealth of the family very much correlates with the race. Effectively, this would mean families of colors get a larger baby bond. It would be put into a trust fund for kids, and they would be able to access it when they turn 18 in order to do things like buy a house or go to school. So that's one example of a targeted universalist program. And so, again, I'm happy to talk more in the question and answer. I want to leave enough time for the rest of the panelists. So target universalism as a matter of policy is one way that we might want to go. Recognizing that I'm talking to lawyers or future lawyers in the room, I want to think about this from an advocacy perspective, right? And so I have 3 suggestions for future advocates or current advocates. The first is to rethink the framing and analysis of legal and social questions, particularly concerning issues of race. And so I just went through a critique of our anti-discrimination framework. And so one of my suggestions is to rethink our frameworks, to do the hard work of putting forward, if you're arguing cases in court, start talking about the anti-subordination principle, to argue why the court should read the 14th Amendment in a way that perpetuates anti-subordination and not anti-discrimination. When Thurgood Marshall and Charles Hamilton Houston litigated the Brown versus Board of Education case, they were rethinking or reframing the way the 14th Amendment was analyzed in a way that was radical. Lawyers and advocates today need to be doing the exact same thing. Start talking about anti-subordination instead of anti-differentiation and anti-discrimination. So that's the first thing, rethinking. And secondly, repositioning. A lot of our most entrenched and pressing problems are not going to be resolved by the courts. As lawyers, I'm guilty of this too. Sometimes we have a little bit of narcissism and think that lawyers are the end-all, be-all solution. That's not always true. Organizers do great work. They're closer to the ground in many instances. And so some of these problems won't be solved by the courts. They'll be solved by organizing, policy, etc. And then lastly, racial justice as practice. And so what do I mean by this? So we need to ground this idea of racial justice in concrete places, events, and group interactions. That means for those of you who are already lawyers or law students going to be lawyers, if you're, and I've seen this happening before, you're working at a, let's say, civil rights organization. The majority of lawyers are white, the majority of staff are people of color, right? In your own workspace, what I mean by this is that we need to conceptualize racial justice in a very real way, affording power to people who are not lawyers, who are in the staff, and making sure that we try and make racial justice a real, concrete, and tangible thing. So I'll stop there, and then I'll turn it over to the rest of the panel.
So I think that we're going to try to have an interactive discussion based on your comments as opposed to kind of each of us trying to talk individually. But I guess I just wanted to start and really focus in on some of the comments that you made from a business perspective, because that's where I operate. Our company, as you heard in my bio, we're a full-service investment banking firm. We are one of the largest minority-owned investment banks in the country. We're predominantly African-American owned. I'm a partner in the firm. And so, you know, one of the things that I see that we encounter really on a day-to-day basis is, you know, what path do you walk down in the context of trying to secure business opportunities? There are, one of the things that Erika referenced was around the Small Business Act. And so, you know, and that was basically put into place originally like in the late 50s, modified in the late 70s, but ended up spawning opportunities for minority business creation through opportunities to secure contracts with governmental entities, through what ended up being programs that exist today with large corporations where they think about supplier diversity, in that the folks that they do business with, that it reflects you know, various constituents and stakeholders and shareholders to assure that kind of that redistribution that's occurring through the spend that our corporation has, that it is getting to various groups throughout the U.S. And so we deal with that in terms of what bucket do we want to be in, because you can, you know, kind of put yourself in the minority bucket, and in fact what ends up happening is that there's almost like a ceiling, right? Because there's only so much that you're going to get, because that's kind of what's been allocated in terms of what we're going to spend with minority and women-owned firms, versus if you're in the bigger pool where most of the dollars are, but then are you likely to get access to them because we still think of you as a minority-owned firm. And so, one of the things that, Erika, you talked about in terms of, what's the action for the folks in this room, who are either currently practicing, will practice, or will be, in different, different roles and opportunities from a professional perspective, is, one of the things that I'd like to see is how it is that we just need to have more people who are, in the room where it happens, asking questions, asking the right questions, and bringing forth the right considerations that are consistent with the information, the great information that Erika shared with us to give us context for how did we get here. And so where do we go from here is we have to have folks who are in the room where it happens. And so for us, as an example, as a firm, we're looking at, the boards of directors, right? And so, there's still, even now, and, there's been work where that's not the case, but even now I can go onto, a Fortune 500 company board, and you can just kind of go scroll up and down, and you'll see, 6 or 7 white males before you get to maybe 1 white female, and sometimes you don't have any at all, and we still have that as an issue. But if you've got folks who are at the table, kind of in that room, they can ask the question there from a board and a governance perspective. And then certainly folks who are in key decision-making roles within the corporations who can ask the question, or be the advocate and bring, some of these considerations to the table around, how it is that that everyone is participating in. How do we get to equality, from a business and an economic perspective? So that's certainly where I focus, and it's a lot of the, the work that we do. We're obviously focused on making money because we're an investment bank, and we have to do that, and I want to do that. But the other piece that I find for me in the context of our role and kind of what our firm is that we also we have to work a social agenda. And I can't say that that's probably the case for maybe my counterpart, at Goldman, right? They don't have to work a social agenda, but we do in order to be able to get access to opportunities. So I would, share that in the context of this discussion.
Hi, everyone. Again, Candace Moore from the Chicago Lawyers Committee. I'm a senior staff attorney that works on education equity issues here in Chicago and in the surrounding areas. And so as I was thinking about this idea of how the law creates inequity and how we can use the law as a tool to push for equity, I sort of settle on 2 examples. I'm going to try to tell them as fast as I possibly can, but they're very complex. It's very complex work, and it has taken a long time, and I'm happy to answer more questions around it. But in my work, 2 big issues that I think many folks who understand education can sort of relate to and understand: the topic of school discipline and school closings. So I want to talk about discipline briefly first, and so how when we look at inequity created by the law. So here, I think it's really important when we're looking at school discipline. I think there can be a tendency to sort of point to individual bad actors and say, well, this student's misbehaving, something's got to be done. Candace, what's the problem? Well, the problem when we look at it is that when we look at discipline here in Chicago, here across Illinois, across the country, we see that there are huge racial disparities in the student populations that's disciplined the most, particularly African American students in a lot of places, especially here in Chicago, and African American boys. And so how is the law creating this, right? So here we look at policies like zero tolerance policies that are supposed to, or in theory supposed to be, I don't care who's doing it, this is what's going to happen. But the challenge is that the way that interacts with the way we've been socialized around behavior, around criminalization. We make choices all the time about who's more likely to misbehave, who am I watching, who am I really concerned with, who is most likely to continue on this kind of behavior. So even a policy like zero tolerance, what ends up happening, it is used to support this idea, well, they did that thing and that's all that can be done. I can't do anything different. Whereas for other students, because that policy doesn't seem fair as applied, we make different choices. We don't apply the policy in the same way. And so what we see is that these types of policies across the board contribute to a lot of disparities in terms of justifying the discipline of students of color, but at the same time, we know that students, particularly white students, are doing the same things and not receiving the same punishment. The behavior is being classified as something else. The other thing is, as we think about a society, how we respond to things like school shootings, right? These are very scary things that happen in schools, and often right after we see an immediate criminalization of our schools, right? We need to get police officers in there, we need to get security cameras in, but these things stay long beyond any particular incident, and often the mentality of criminalization, we are looking for crimes, we want to stop things before they happen, often is over applied to students of color because of the way in which we imagine criminality to happen. When we think about the term criminal, when we think about who is criminal, many of us, if we sort of close our eyes, a visual would pop up. And often when times we're talking about race, it is often a black person, a black male, because we're inundated in society with those images and those visuals, and those impact our judgment. And so the way the law interacts with the way we've been socialized creates these huge disparities in schools. And so that's sort of like the quick and fast version of that. But then what can we even do about that? How can we use the law as a tool to begin to solve these things? So here in Illinois, and I really appreciate what you brought up about this can't only be the work of lawyers, it really does require us working in communities of young people who were directly impacted by this issue, began to craft solutions. They first crafted solutions for their own school district. So here in CPS about 4 or 5 years ago, major overhauls in how we did discipline in the district, and it's caused huge numbers of exclusionary discipline to go down. Those young people saw some of those wins and then went on to champion a piece of legislation at the state level. And so now in Illinois, we have new statewide legislation sort of called SB 100. It's not a Senate bill anymore, but everyone still calls it SB 100. That's ushering real accountability when it comes to discipline. Schools have to have standards about how they're making their discipline decisions. Schools have to be accountable for the disparities. So right now in Illinois, over 80 schools have to commit improvement plans for how they're going to deal with the fact that their school has been pushing out disparities at sort of the top categories of all schools for 3 years in a row. So these are reforms that are actually happening now that are meant to sort of curb what we've been seeing. The other thing I'm going to talk about just super briefly is school closings. So for folks who live in Chicago and many people who don't, we're familiar with the 50 school closings that happened in 2013, right? It was historical. And the justification for those school closings largely was sort of claiming that these schools were underperforming and they were underutilized, and because of population shifts, the district really needed to close these schools and really focus on investing in a smaller number of schools. But for many of the reasons, again, that you named around the ways in which society is stratified and resources exist, these schools were predominantly in African American communities. And so the 50 school closings disproportionately impacted students of color. Sort of fast forward to the summer of 2017, National Teachers Academy. How many people, just by a show of hands, have heard about this? I know one person is a parent at National Teachers Academy. National Teachers Academy is an elementary school. It's located really close to the South Loop, an amazing school. It is not underutilized. It is high performing, and in fact, it is performing at the highest rating that a school can get in Chicago public schools. Unfortunately, in the summer of 2017, the district decided to close that school. They decided to close that school. Oh, I should also add that that school serves 80% African American students. which is really kind of unheard of when we think about the racial disparities around performance in the district. But the district decided to close this school to turn it into a high school to meet the need of a really fast-growing neighborhood, the South Loop, one of the most affluent neighborhoods in Chicago. And for many different reasons, many folks in the community saw this as racially unjust. Right? Would this happen if this school did not serve 80% African American student population? In fact, there was no history of CPS ever closing a school that had top ratings and in this sort of utilization. So why was it happening? Why was it being allowed? What can we do? So when we think about solutions, I would again point to the fact that the first part of the solution was the community coming together to tell their story about the impact that this kind of closing would have. Showing up at every testimony, doing racial equity impact assessments and reports and submitting to the district. Unfortunately, the district decided to still close the school. And so that became a point where us as lawyers who were working with the community filed a lawsuit. We filed a lawsuit that had five different claims, 4 under that alleged violations of the Illinois School Code, and 1 that alleged a violation of the Illinois Civil Rights Act for racial discrimination. To make a very, very long story short, when we got to court this past December, and we were pursuing a preliminary injunction. So when we got to court this past December, we actually lost on 4 out of our 5 claims. All the claims where we alleged violations under the Illinois School Code. The only claim that we survived was the Illinois Civil Rights Act. Right? And that was really important to us because we were pushed to really craft a claim that went to the heart of the problem. Why was this a racially discriminatory decision? The way the district had made this, the way they made this decision would have disproportionately impacted any school that had majority African American students. And so a lot of this was about having the courage to name that and to claim it and be honest about that, but to also tell the history of how we got here, to say that this wasn't a one-time scenario. And so that really sort of supported this lesson, this idea that when we name it, when we frame these things, when we're honest about what's going on, we really can see solutions coming out. And it was, in fact, I think one of the things we learned is that this may have been the first time that a community was able to stop school closings using a race-based claim to stop a school closing. So it was really important to the community, but it really had a lot of importance for all of us that do this work.
Yeah, one of the most sobering things that Erika talked about, I think, was right at the beginning, and those charts on wealth disparities. And one of the major determinants of wealth is housing. Whether you own your house, what is the value of your house, and your value is generally determined where your house is, what is the character of the neighborhood, and everything. And all of that is tied very deeply into discrimination. If you want to do discrimination law, and particularly housing discrimination law, you are in the right place at the right time. Because Chicago consistently is listed as one of the most segregated cities in the nation. And if you don't believe it, just when you're going home tonight, look out your window, and I think it's visible to everybody. And I think it's important to remember when we talk about housing, this is the Martin Luther King Conference. And Martin Luther King's only major northern campaign was in 1966 in Chicago, where he led an open housing campaign and had marches in Market Park and Berwyn and other areas of Chicago. And historians generally say that was Martin Luther King's least successful campaign. I personally think he accomplished a lot during that period, and in terms of highlighting the problems of housing discrimination. But at the end of the summer, Martin Luther King was supposed to have said that he never saw such hatred as in Chicago when it came to open housing, that nothing in the South, Birmingham or New Orleans or no place, Mississippi, could match Chicago when it came to housing discrimination. Now, we all know that the very first civil rights law passed by Congress in 1866 specifically addressed discrimination in the ownership and leasing of property. So immediately after eliminating slavery and defining United States citizenship, the Congress said that the right of Americans to own or lease property free from discrimination on the basis of race is fundamental. And yet we know that statute was vetoed by the president. It was passed again. The 14th Amendment was largely passed to make that law constitutional. But it wasn't until 1968 that the United States Supreme Court finally said that that law was justified under the 13th Amendment. It didn't require state action as other statutes passed under the 14th Amendment because housing discrimination was a badge or an incident of slavery. And using the language in 1968, the court said herding African Americans into ghettos was a clear sign of inferiority, was a clear badge or an incident of slavery. So from 1866 to 1968, housing was fair housing, anti-discrimination in housing was really aspirational. And as Erika pointed out, the separate but equal doctrine, the state action doctrine, all the policies of federal government, state government, private discrimination conspired to create segregated housing, particularly here in the North and particularly in Chicago. Also in 1968, Congress passed the first Fair Housing Act. Why wasn't it passed in 1964 with the other civil rights laws? It was too controversial. In fact, if you might remember, those of you from con law, in 1966, or 1967, I think it was, the Reitman versus MLK was argued before the Supreme Court, where it was argued that California could make the right to discriminate in housing a constitutional right. And that was generally the thinking in 1968, that people had a right to sell to whomever they wanted to. People had a constitutional right to rent to whomever they wanted to. The Fair Housing Act, in many ways, ended that. The Fair Housing Act prohibited discrimination on the basis of race, color, national origin, and religion. You might note that something is missing in there: sex. Congress included sex in the Civil Rights Act of 1964, did not do it in 1968. It wasn't until 1974 that the Fair Housing Act was amended to include sex discrimination. It wasn't until 1988 that Congress expanded the Fair Housing Act to include persons with disabilities and families with children. And frequently before that, discrimination against families with children was frequently based on race, color, or national origin. The 1968 Act was really revolutionary, but it had very minimum enforcement measures. So it wasn't really until 1988 that real teeth was put into the Fair Housing Act that enabled it to be effectively enforced. So again, you think of housing and housing patterns being established and very little in the way of remedies up until finally the Fair Housing Amendments Act of 1988. One of the important things I think to remember about the Fair Housing Act is that the original Fair Housing Act had one clause in it that is not in any other civil rights law. And it addresses the problem Erika talked about in terms of affirmative action, because the Fair Housing Act says that the Secretary, the federal government, federal agencies, all recipients of federal money have an affirmative duty to further fair housing. That has not been interpreted as an affirmative action requirement, because you can affirmatively further fair housing without so-called discriminating against white people or other persons. You can affirmatively further fair housing through inclusionary zoning, through inclusionary advertising, through inclusionary policies. The problem with affirmatively furthering fair housing is the first Secretary of HUD, George Romney, took it very seriously and started to really enforce it, and President Nixon quashed that. And so it really wasn't until Obama, President Clinton, put some measures into affirmatively further fair housing, but it wasn't really until the final years of the Obama administration that HUD adopted a rule requiring local governments to receive federal money to affirmatively further fair housing, and to do that as a condition for receiving funds, and to actually submit a program to the federal government that would show how they would do that. It's probably not surprising that that has been one of the major targets of the Trump administration in recent years. But that is still the requirement. Even if the administrative rules enacted by the Trump administration are not enforced, there is still a duty of public officials to affirmatively further fair housing. The other thing that I think is important to recognize is that the Fair Housing Act has a disparate impact standard, much the same as employment discrimination. And again, Justice Kennedy, just recently in the Inclusive Communities case, recognized that long history of housing discrimination, and the fact that once housing patterns are in place, they're not easily erased. In fact, recent studies show that those areas that were covered by restrictive covenants in the 1950s and 60s and 70s, if you look at a map of where the restrictive covenants occurred and the racial makeup of those communities today, you can track segregation exactly by where there were racial restrictive covenants up until they finally became illegal in 1968. We know they became judicially unenforceable in 1948, but people could still do restrictive covenants so long as they didn't go to court to enforce them. So housing is a key factor in what Erika was talking about. It's important for voting rights. It's important for schools. Mm-hmm. Segregated neighborhoods produce segregated schools. It's important for jobs. It's important for transportation. It's important for everything in life. But it's also, to me, and what I see, we have a fair housing clinic at the John Marshall Law School, is housing discrimination probably does the most individual damage to people who suffer discrimination of any act of discrimination. You can be told you can't vote, you can be told you don't have a job, but it isn't quite as personal as you have the money, you go to rent or buy a home, and you're told you're unsuitable to own that home because of your race. That is directly against a person's dignity and has long-term effect not only on that individual, on their entire family, on the neighborhood, and everybody else. So think of housing discrimination, think of Chicago, and what we need to do here in Chicago about that problem.